Alex here with part 12 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to direct my viewers to part 0 of the series. That is the video that contains the detailed disclaimers and the underlying purpose of the series in general. Two things I will glaze over, however, are number one, I am not in the middle of this right now. My case is completely and totally closed. My ex's parental rights have been terminated. My case cannot be reopened. Number two, the purpose of the series is to create one big gigantic example in chronological order of my 8 years long high conflict child custody dispute from beginning to end. Where we left off in part 11 is basically having to deal with a motion that my ex filed in the domestic relations matter that should have been filed in the child custody action. And where we left off in part 10 is the discussion on the written orders entered by the domestic master extending my ex's order of protection. In this video, we also will touch on issues that were mentioned in part 8 of the My Docket series, which have to do with mediation. My ex had filed a request for mediation, and I, in this video, will discuss a response that I filed to that request. That request for mediation was filed in the child custody action, which is the action I instituted in part 1 of the My Docket series. If you haven't figured it out yet, this kind of is a mini justification for watching the series from beginning to end in order, because as you can see, most of these videos are getting to the point where I have to refer to what's been discussed in previous videos, and I'm not going to reiterate anything for the viewers that are watching the series from beginning to end. My response to the request for mediation is pointless, and my response is just that I agree to it. There is no reason to even have filed it. And I almost thought this video would be boring, but I can still teach people, or at least explain to people what I was thinking at the time, and hopefully people learn from my actions, and also explain to people kind of what it is that causes these types of responses. It's not really juicy at all. It's just a 2-page response saying, okay, I agree. I think that this comes from two main emotional points, I guess you could say. Number one, the paranoia of not filing something. When you're representing yourself in court, you are paranoid that everything requires some kind of response. And if you don't respond, you might waive your right or somehow lose your case based on a technicality. This is a concern with certain types of papers and pleadings that are filed, but not all of them. And this is why it's so important to learn as much as you possibly can about the legal system when you're representing yourself. A lot of people think, well, since I have no hope in learning at all, I may as well not even try to learn some. And that's just a terrible attitude to take in these types of situations. Sometimes you can't learn it all, but you might learn something that affected your case or affects your case going forward, that causes you to not make a mistake that you would have made. Just because you can't learn everything doesn't mean you should just not even try at all and just sort of go into court and at the mercy of the judge beg for what it is that you need to happen. It just doesn't work. The second thing is, it's sort of this idea that you want to be heard at every opportunity. So this one isn't so much a paranoia or a fear that you're going to somehow waive your rights by not responding. This one is more a craving for relevance. You're representing yourself, your ex is an attorney, they're usually communicating to the court a whole lot more often than you are, and so there's this urge to speak up, to speak out at any opportunity that you possibly can. And both of those are going to be very common for somebody who's representing themselves initially. After several years, you hopefully figure out that this isn't necessary, and it just kind of makes you look like all the other people who represent themselves, which, as I've mentioned in the series, is the thing that you want to get furthest away from. You want to represent yourself and look different. You don't want to get lumped into all the other people that do it, because the general idea is you don't know what you're talking about, you're annoying, you're wasting everyone's time, and go away. If you can separate yourself from that swarm of people and look different, you can sometimes, not always, sometimes get different treatment from the judge than you would ordinarily get. I explain in detail what I'm talking about in the video, self-representation bias. You can usually, which is an upgrade from sometimes, get this level of respect and treatment after you start winning some appeals. And that is something that I talk about in my video, Deserve Victory. So getting past kind of my mindset as to why I filed this pleading, this pointless pleading, I also want to explain why it's pointless. When somebody files a request for mediation, they're citing the court rules as to how it works. And if you, first off, it's not a motion. So if you don't want, if you want to know why that matters, watch my video motions. Motions are a formal request citing points and authorities, which includes legal analysis and a factual background as to why the court should give something that is being requested. If something is literally titled a request, usually you could check the court rules and it's based on some kind of trigger effect, something that doesn't really involve a debate. And in this case, we have court rules in the state, one of them which states that mediation is mandatory, at least the first time you go. And so this request for mediation that my ex was filing is basically citing that rule, saying, hey, mediation is mandatory, please schedule it. Now, there could be cause for a response, some kind of way to object or oppose that request. But if I was going to do so, it would need to be based not on my personal idea as to whether or not I wanted to do it. It would need to be based on the actual court rule that was cited in the request. And that court rule has subsections in it, one of which discusses when mediation is not appropriate. And so if I had some kind of objection, I would have filed an objection citing one of those exceptions and explaining why. And then the court would make a decision as to whether or not it was going to order mediation. But if I have no objection, I shouldn't even file anything. Nothing should have been filed. I shouldn't have prepared this. I shouldn't have served anything on my ex. I should have just let the request for mediation just sit there, and eventually the court would get around to doing something with it. But again, this is a learning experience, so let's take a look at what I actually have filed. Here we have the response to motion that I filed. Now this wasn't, it's hard to really kind of get into this, but I was going to say this isn't the form that I should have used, but as I mentioned earlier in the video, there wasn't really any response at all that was appropriate, at least not one that just kind of agrees with what's being requested. If I had an objection, that would be different, and that would be on an objection form, but there's no objection to this request. And so I was trying to find a form that might really line up with that or match with what it was I was trying to convey to the court, but there wasn't one, so this was the closest one that I could find. If you find yourself looking for self-help forms and you can't find one that really matches up with what you're trying to do, yeah, you could go and find the next closest thing and just kind of fit what it is you're trying to fit into those blanks. But ideally, what you should do is check or inquire into whether or not whatever it is you're trying to file is even something that needs to be filed. And one of those things that the self-help centers and the lawyer and library programs are great for is answering little technical questions like that. Moving on, you'll see here that I referred to the request for mediation in this blank here. Even though it's not a motion, the court will get the gist of what it is I'm trying to do. By the way, you'll get leeway. You'll be given a lot of slack when you file things that are weird in court when you're representing yourself. But don't ever embrace that. Understand it, be okay with it, but don't think that that's kind of okay, an okay position to be in. These high conflict child custody cases go on for years, and you want to transition towards or evolve into a situation where you're taken seriously. And you're going to get taken more seriously when you file documents, first off, that are custom, second off, that are consistent with the rules, that are consistent with what the court is used to seeing in, if it's being briefed. So for example, if it's a motion, opposition, replies, briefing, you know, the point is you want to get to the point where you aren't doing weird things and just getting a lot of slack. You want to get to the point where you are keeping up with your opponent's attorney. And it's so frustrating to say something like that because a lot of people say you'll never be an attorney, you can't practice law. But Nobody's doing this out of choice. If people were millionaires, they would hire attorneys to deal with these problems. The people that come to this channel are forced to represent themselves. And if you're representing yourself, you have to do things as close to the law or as close to the way in which an attorney would do them as you possibly can. And that is all covered in the multitude of videos that I've done in the past on representing, yourself. And so I just wanted to really underline that. Don't just be okay with filing weird documents and being cut slack. Accept it in the beginning, but definitely keep moving towards the goal of being taken seriously by the court and your opponent. It sounds insane for so many people, I think, because of where they are right now. But as you see me get to year 3, year 4, year 5, year 6, year 7, you're going to start to see that I am getting respect from the judiciary and the attorneys. They're not going to necessarily be making competent decisions, because 3 of the appeals that I won were between years 6 and 8. But at least your documents are going to be given more consideration, are going to be taken more seriously, and you yourself, when you say things, the court isn't just going to lump you into the gigantic blob of non-attorneys that just annoy everyone, they want to get rid of, that don't know what they're doing. And this is one of the most difficult topics to go over, because there's this idea that you're stupid if you represent yourself, but stupidity implies a choice, and it's that correction that I'm trying to really get people to accept, that people who represent themselves do so because they are forced to, not because they think, oh gee, I'm just going to save all this money and do it myself because I'm smarter. Like, no, that's not what it is. And in fact, if you watch my video representing yourself, I go into a whole lot more detail on this topic. So moving on in this form, towards the bottom of page 1, I agree to the request, and I just asked that my ex file a financial declaration form. Next page is just a bunch of blanks. Down here, I do not request a hearing on this matter. I get a lot of questions on this. What is the point to requesting or not requesting a hearing? Letting the judge know that you want an additional opportunity to discuss the document that you're filing. I used to think that this was a request for an evidentiary hearing, but apparently that's treated in a completely different way. Whether or not parties get an evidentiary hearing is based on whether or not parties have shown adequate cause for a hearing, at least in a child custody situation. So if a judge, and I've seen this actually happen before, I think it happened last week or maybe 2 weeks ago, there was a situation where a judge got briefs, motion opposition reply is what I meant to say, or at least is more specific. A judge got a motion opposition and reply, and both parties did not request a hearing, and the judge made a determination that required fact-finding, but he decided, since nobody wanted a hearing, he was just going to decide what the facts were. And one of the parties filed a notice of appeal. The losing party filed a notice of appeal, and the Supreme Court reversed, and they reversed his decision, saying that he needed to set a hearing and determine certain facts in that case. And it didn't matter that the party said they did not request a hearing. My understanding, though, is that this little request here has nothing to do with evidentiary hearings or trials in the first place. It's for people who want a hearing to go and discuss the law. They call them law and motion hearings, and I think they may also call them appearance hearings. It's a hearing where the parties just show up and talk about what it is they filed, and they further bolster whether or not they think that a hearing is appropriate or required, and whether or not there is no point to it because there's just no genuine issues of material fact for the court to make findings on, and so the court can just make a summary ruling right then and there. There's a whole lot to what it is I'm trying to say, and in fact, it may be better for you to just watch my video on hearings, and I also have another good video that covers the gist of what it is I'm trying to explain, and that one is titled Motions. So definitely watch those 2 videos if you want to get more into how it is you go about getting a hearing, and also, even more importantly, the different types of hearings. My usual course of action was to not request a hearing on anything that I filed, and that is because I knew that I was better in writing than I was in person. At the time that I kind of went along with this idea, it wasn't because I understood the point of any of those hearings. It was just me saying, I'm not good at hearings. I'm not an attorney, I'm not always in court like they are. I'm better at writing, and so I would always, or most of the time, I would not request a hearing on the matter. Later on, around years 6, 7, and 8, I figured out that the different types of hearings had a purpose. Each one was different or unique as to what it was that the court would accomplish at that particular type of hearing. And then I also learned a whole lot more about the purpose of evidentiary hearings and trials specifically. Scrolling down, we have an affidavit in support of my response. I don't even think I alleged any facts, so there's probably no point to that, because all I did was just agree to it. Yeah. Scrolling back down. So the point to affidavits like this is to swear under oath that the facts you are alleging have occurred are true, and it basically subjects you to perjury charges if you're lying, and possibly even contempt of court. Scrolling further down, we see the notary public, Gloria Solorzano. So this was not the self-help notary public, or at least maybe it was. I don't remember this one though, this Gloria person. Scrolling down, this is the affirmation I talked about in most of my videos. It just lets the court know that there are no social security numbers in the document. Scrolling down, this is the motion opposition notice. I would have ended up paying a fee if the circumstances were different, and that would have been silly because this is not an opposition to a motion. I've talked about the motion opposition notice. It just contains a flow. I don't want to call it a flow chart. It contains a list of check marks or check boxes that flows down from top to bottom, and depending on the marks that you put in the boxes, you may or may not have to pay a $25 filing fee. And in this case, I marked no. Another affirmation sheet. Seriously? Yeah. Okay, so it's just I prepared this this affirmation to swear under oath or affirm that the motion opposition notice didn't contain the social security number, which of course it doesn't, and you don't need two of these in one form. So yeah, this is me just early on in 2008, year one, and filing or attaching filing documents that aren't required and attaching papers to documents that are superfluous. But that's just what you do when you're representing yourself because you just don't know. I also remember being turned away on multiple occasions for not having the affirmation. So I was probably paranoid at this time, having been turned away from the courthouse probably a number of times, maybe 6 or 7 at least by this point. To file even my first document, I was turned away 3 times. There was just things that I had not done correctly. Anyway, just out of an abundance of caution, I attached a second one. Let's move on to the next document. This is an affidavit of service, also not really required because you could just attach this to the back of, or attach this as the last page to any custom document you're filing. But I'm not using custom forms, I'm using self-help forms, so I had to get an affidavit of service. And I'm just marking the box that says I'm a party to the action representing myself, and the date that I served a copy of these documents on my ex. I'm even listing documents that I didn't need to serve my ex with. So the notice of case management conference, which by the way is listed twice, is just, it's something that the court sent to us. So my ex, her attorney, would already have this document. I wouldn't need to serve it. I didn't prepare it. I didn't file it. The other documents are case management conference statement, and it looks like I am swearing under oath to having served the financial declaration. Oh, by the way, that financial declaration I went over in part 10 of the My Docket series if you want to take a look at it. Documents were served by mail. They were not. I dropped these off at the lawyer's office personally, which is not something I had to do. I could have served them by mail. I've talked about this many times, but there are 2 court rules that contemplate service of process. NRCP 4, Rule 4, which deals with service of the initial pleading, which is the summons and complaint in this case, or the summons and petition. That has to be served personally by a disinterested third party. Rule 5, NRCP 5 service can be served by mail. You don't have to serve them personally. You just drop it in the mailbox, mail it to their house, and you also are allowed to serve your own papers by that point. You don't have to find a disinterested third party to do so. Another affirmation at the back of this sheet, and that covers the documents in this video. I'm going to also go ahead and go into the first mediation because it wasn't very eventful. It wasn't constructive at all. And it's not really going to deserve its own separate video because mediation is not recorded. There are no transcripts of mediation. There's no video that I can download or upload to one of my my Docket series videos and show my viewers how mediation went. And so it doesn't really deserve its own video. I'm just going to cover it now. What my ex did in mediation made it totally pointless. She thought of the mediator as a judge. She thought of the mediator as a person that she needed to get on her side. And so we weren't really communicating in the sense that we were trying to work towards a resolution. It was just like an extension of court. It was like she was presenting evidence to the mediator and, characterizing me horribly. All of these allegations that she raised throughout this case, she continued to raise to the mediator, so the domestic violence. And the quickest turn off to wanting to work with your opponent is right away they go right back into lying about you and trying to turn it into a power struggle, which is not the point of mediation. Mediation is supposed to be about coming up with a settlement, and settlement takes compromise. And if you're going to go in there and bash the other side or assassinate their character or like quite literally argue your case like it's a trial, then it's a total misuse of the process. The mediator has no power unless we agree, at least in Nevada. In Nevada, a mediator cannot enter some kind of order. They can only send a mediation agreement to the judge, which then the judge converts into an order. And if you agree, the mediator will put together the terms of the agreement and send them up to the judge. If you don't agree, the mediator sends a one-line statement to the judge. It says something like, parties appeared for mediation on this day, parties failed to come to an agreement. That's it. That's all it says. There's even a rule that says that the mediator has to say as tersely as possible, as a matter of fact as possible, that the parties didn't agree. The mediator is not allowed to say, this person was unreasonable, they almost came to an agreement on these 4 issues, they were agreeing about this, this, and this, but since they didn't agree as to that, they decided not to sign any agreement on anything. This person acted ridiculous, or I believe that this person's an abuser, or I was told these 3 things and I think they're true. They don't do anything like that. So there's no point to trying to get the mediator on your side because the mediator can't prepare anything like that and send it to the judge. And I'm not sure if she knew that. In fact, I'm pretty sure if she did know, she didn't care, because we had 2 more mediations after the first one, which I'll cover in other videos, and nothing happened in neither one. In all 3 mediations that we went to, we didn't come to an agreement. We litigated on all 3, and I won on all 3. So by not agreeing, I ended up getting what it was I wanted anyway. A whole lot more than what I wanted, actually. So if you want to learn a little bit more as to how mediation works, definitely watch my video, Mediation and Settlement. And if you want to know any more as to what happened with my mediation, with my very first mediation, post something down in the comments below. I'm not going to have anything good to tell you that I've already covered because it was like another court case, except this one wasn't recorded and we didn't have a judge. So it was like the pointlessness of it cannot really be stated with just words. It's kind of one of those things that you have to go through. It's like a Twilight Zone experience. Like, what are we doing here? So anyway, it was pretty awful, and it was not just an extension of the litigation, but in many ways an extension of the manner in which she abuses people. I'm not even going to say the manner in which she abuses me, because she did that to everyone. It was just how she treated people who were close to her. It was always about being right, winning, and devaluing the other side. And that's a key word here, devaluation. It was not really a constructive debate as to what was best for the child. It was character assassination and nonstop devaluation in front of a mediator. So going into the aftermath, we are not going to have a whole lot to adjust with regards to the financials. Neither of us incurred any costs here. I was the one that filed these two documents, and neither one entailed any kind of filing fee. I served them myself, so I didn't have to pay any service of process. My ex, she would have also, well, she didn't file anything, so of course there wouldn't be any filing fee. With regards to attorneys, though, there is a little bit of a difference. I, of course, had no attorney, so I didn't have to pay any attorney fees. But she did have an attorney, and the attorney would probably have charged her 15 minutes to review both documents, to review the response to motion that I filed, which was actually in response to a request for mediation, and the affidavit of service that I filed. So if we're going to go with a $250 an hour rate that we've been going throughout the series, or going with throughout the series, that's going to come to $62.50. No, yeah, that's about right, $62.50 in attorney fees for my ex. So if you have any questions, again, post them down in the comments below, and I will see you guys next time.